Hello, hello, hello. This is Attorney Mike Gravel coming to you from Chicago. As usual, sorry I'm late for, by happy hour standards, I'm certainly late, but opposing counsel just kept asking the same damn questions again and again over 3 hours. 3 hours in my deposition. Sorry. This isn't just happy hour. It's also my therapy. I got some good clips. I got a good one out of Stanislaus County out in California, which I find really interesting. And then we've got some more quality time with Judge Manning, which I haven't really had a chance. I saw a little bit of it. The prosecutor that made you guys all crazy is back, and he's being chippy again. That's all I know. But most of it I haven't seen. We'll see. I don't know. It doesn't matter. It's an excuse to have a beverage with each other. Why not? Let's do it.
Calling the case of the People versus Benjamin Johnson. It's case number CR 22 Tech 7263. Mr. Johnson is present in court. He is here with his attorney, Mr. Moth. The people are represented by Ms. Jones. Good morning, Mr. Johnson. When you were last here, you were considering, you were going to fill out that paperwork asking for the court to authorize you to represent yourself. And Mr. Moth, before I called the case, indicated that at this point in time, you are not making that request. Is that correct?
Yeah.
Okay. So what did you want to do, Mr. Moth?
We're just going to set for preliminary hearing.
Without a time waiver?
He's withdrawing his time waiver. I believe
Okay.
you're withdrawing your time waiver. Keep your time waiver.
What do you mean? What's the time waiver?
Because you waive time, you know? So did you want to keep that or do you want to pull your time waiver?
Did you wish to continue to waive your right to a speedy preliminary hearing, or are you now demanding a speedy preliminary?
Okay, go with me on this. I like to think that this defendant, although he's incarcerated, saw some of the Waukesha case and thought, you know what? I'm better off with an attorney. Because he wanted to represent himself, but if I like to think he saw some of that and thought, no, you know what, I can go with an attorney, and it's immediately confirmed because the next question from the judge he doesn't understand, which makes sense, and the attorney starts to explain it to him.
Hearing.
Oh yeah, I want to go. Yeah, I want to waive my.
Speedy.
Yeah.
Okay, so you do have that right to have a hearing within 10 court days, no later than 60 calendar days. Do you waive your right to have a preliminary hearing within those time frames?
Yeah.
Okay, so let's pick the next court date. How much time do you think you need to speak with your client and be prepared for preliminary hearing, Mr. Moth?
I'm going to be at trial for the next several weeks, so it might take me some time. Perhaps we could set the prelim in December.
Okay. Let me take a look at, I have the calendars here.
We'll have some fun, Colin.
About an hour estimate, Your Honor.
Nice to see you.
Let's go off the record. I'm looking at the last week of December. I don't know if you're vacationing on vacation or not, Ms. Jones. Sometimes people do that last.
I won't be here the last week in December.
And what is the expected length of this preliminary hearing?
Roughly at 1 hour.
Yes, it's a good thing Miss Bristow has a sense of humor. I thought we might have, but I don't believe we've scared her off yet.
I could set it for January 17th through the 20th. I'd like to set it in the afternoon if you anticipate having witnesses here that are minors.
I do.
Okay. Any of those days work for you all?
That's fine.
Yes, Your Honor. Is that Monday available?
No, it's a holiday. That's probably why it's clear on your calendar.
Thank you. The 20th available?
It is. So we're all right. Back on the record, we will set the preliminary hearing January 20th at 1:30 in the afternoon. And Mr. Johnson, your order to appear, and we'll see you back at that time for your preliminary
I
hearing.
say something, Judge. I still haven't got that paperwork either.
Okay.
You had instructed him to give to me that new discovery. I still haven't got that, and that's important.
Okay, Mr. Moth, are you able to?
I made a request, and I'll reemphasize the request.
All right, I think it's underway. It's in the process of getting
What
to.
if I don't have it by the time we come back.
You'll have it by January.
I'm pretty confident that you'll have it, but if you don't, just call the public defender's office and remind that you haven't received it.
So that's just that.
Well, there's no order for me to make. There's nothing. I mean, because Mr. Moth is doing what you're asking for him to do. It's
He's
just
not doing what I'm asking him to do if he ain't giving me my new discovery, man. I'm not trying to be confrontation, but
no. I understand, but
he hasn't seen me since my last court day, man.
he's been in trial. I know that because he's been in trial next door. So in a really serious case, actually. So I just think you have to be a little bit patient.
But my life is on the line, man.
I don't disagree with that at all. And
I think the judge handled it really well. The guy's like, I don't have my discovery, which I get from his perspective. It's not even crazy. It's the thing, but he just doesn't understand. Well, now you have an attorney. Since you made that wise decision, if you're not getting discovery, he can file a motion. You're not up again till January. If they show up in January without having turned over discovery, the case will probably get dismissed by the judge. But again, his concerns are valid, but now that he has an attorney to buffer it, it's going the right way. But I like how the judge vouches for him. Yeah, maybe you couldn't get a hold of your guy because he was in a huge trial next door. I saw him every day.
asking you to be a little bit patient. All right. Well, I'm confident that you'll get it in time before your preliminary hearing. So we'll see you back on January 20th at 1:30 in the afternoon. All right. Thank you.
Oscar says hit like and subscribe. Well, and hit the bell notification. Thanks, Oscar. I always think that.
I have to go see my.
No, that's not him. Okay.
There you go, trade with me, Miss Fantasia. Just made you back the host.
Okay, I'm about to make you the co-host.
All right, so Hernandez is in Cobb too?
Yes.
Does Hernandez need an interpreter?
He does not.
He does not.
Okay, is that the one we're taking first?
Yes, Your Honor.
Oh, it's
All
coming.
right, we got court reporter, we got pretrial, we got everybody. All right, and this is my understanding on add-on on position one. This is Daniel Hernandez Nava 21CP204646. My understanding, all we're addressing is one criminal trespass. Is that right?
No, Judge, that's incorrect.
The other ones have bonds, and I think he's made.
Here's the problem. So the last order that the court entered, he was given bond on a charge that was previously dismissed. That was the criminal damage to property. So that should be vacated.
Okay.
There are 2 counts of criminal trespass.
So we set it on one.
I'm sorry?
Oh, we need to set it on those 2.
That's correct, but I have also filed a motion to reduce the bond.
Okay.
It has been more than 60 days since his last bond hearing, and I have repeatedly been trying to get in touch with the DA's office to work this case out.
Okay. So it's a 21CP204646, aggravated assault, disorderly conduct, cruelty to children, third, obstruction, criminal trespass. That's right, Ms. Hanson?
That's correct.
All right. Trial.
Pretrial. I don't really like this layout. It looks like I'm an inmate here.
You know when I say that, that's my little wake-up call for Bostic. She still doesn't pay attention.
Excuse me 1 minute,
It is. It's a signal. When she says pretrial, that means attorneys on this thing start talking.
Your Honor.
All right.
What you say? I missed it.
3 South, pull your door up and have a seat. 3 South.
Judge, what did you say?
Go ahead. We're doing the add-on. It's Hernandez.
I think I can get it done.
Hernandez has a hold in Sandy Springs for an FPA. No felony convictions. 3 arrests total, including this one. Criminal trespass conviction and arrest for probation violation. Nothing further.
Case.
What do you think is wrong with it?
I don't, well, 1, I don't see that he has a hold from Sandy Springs. 2, he had a juvenile case, but to my knowledge, he doesn't have any other arrests.
I really should just wear
What's the
orange for one of
defendant's
these.
name?
Daniel Hernandez Nava.
I just ran that this morning, and that's what I came up with.
Okay.
I just ran that probably like
Mhm.
30 minutes.
Okay. Fine.
So, all right, so Miss Tracy, so on the actual old bond order, where it says criminal damage, so we'll vacate that one, okay?
Which one? The first one?
So count one, the criminal damage to property, that was dismissed. So we'll vacate, it's okay? All right, go ahead, Ms. Hanson.
Your Honor, I would ask for Mr. Hernandez to receive a UJR on both counts of criminal trespass. He's eligible for UJR, as well as on the other misdemeanor counts, the disorderly conduct, the cruelty to children in the third, and the obstruction. The aggravated assault, I think 3,000 is reasonable. He has been in custody at this point for nearly a year on an unindicted case. The alleged victim in the case is his brother, who is known to the state, whose whereabouts are known to the state. In fact, he is a defendant in a trafficking case that has been indicted. So he was lucky enough to be arrested after COVID and have the state have to hurry up and indict him within the statutory 90 days. Mr. Daniel Hernandez is not so fortunate. I think that's reasonable, Judge. I have tried to reach out to the DA's office in order to resolve this case repeatedly. No one responds. I have finally taken it up to Ms. Willis. Nobody has responded. So I think it's reasonable, and I think under the circumstances, he should receive that bond.
All right. Mr. White, any contact? Now, I've got like 329 days, but I think there's reason for him being in there 329 days. Am I right, Ms. Hanson?
I'm sorry?
Is there reason for the 329-day incarceration?
No.
So he hadn't been able to.
This defense attorney Hanson is good. She's feisty, but I like it. Is there? Oh, there must be a good reason. No, there isn't. He can't make bond. That's it.
Okay.
He can't make bond. He has no family to make bond for him.
All right, there you go. Go ahead, Mr. White.
The answer to your question, Judge, is yes, the state's actually had considerable contact with the victim, and as pointed out by my learned colleague, the victim is currently under indictment for issues of his own.
X.
I would lose my mind dealing with this guy. I'm sorry. I would.
I'm just trying to see where we're at with I'm a little bit confused about
where we're at is the guy's been sitting in the can for over 300 days and you haven't indicted him. That's where we're at.
What the argument is on bond.
Well, here's the thing that at preliminary, the criminal damage property had been dismissed, but her argument is he's sitting there for 329 days without indictment, and he can't make at them, which was an $8,000 bond.
And that there's no reason that he shouldn't have been indicted at this point.
Yeah, and then there's no.
And I volunteered to waive indictment.
I love Judge Manning. And there's that. Yeah. There's that no indictment for almost a year now.
Go for an accusation, and that has not been responded to by learned counsel.
Well, okay, I can respond to that right now. That doesn't happen in this administration, Ms. Hanson.
Oh.
And I think we've had that discussion on multiple occasions in the past.
I have a case.
So thank you very much. We will not entertain.
Look how cranky he gets. I mean, I think he's out of hand right here. He's nicer later in the call, but I think he's out of hand. I saw him first time when the person was in jail for 90 days. They ultimately let him out. But he came over and he didn't really get in the way, but he was cranky. And I thought, all right, maybe he's having a bad day. No, that's how this guy operates. I would cram that down his throat if he was talking to me like that in front of a judge. He would feel the sting.
In jail 600 plus days without indictment.
Mr. Cho, we will not entertain that discussion in the future.
That's incorrect.
We'll entertain any discussion that I want to have on behalf of my client.
Is all I'm saying.
Okay. Go with your bond argument.
the bond is certainly more than reasonable in this case, and there's absolutely no reason for, there's been no change in circumstance. There's no reason to disturb the bond. As to the criminal damage of property, it was just, and because I show a bond.
Well, it was, but that was a mistake on the bond order. You look back and it was the criminal damage to property was dismissed. There was a flaw in the, it was dismissed. There was no.
Okay, and so what we're doing is we're just.
So I don't know what charges are still pending, but I'm absolutely certain that this guy should stay in jail indefinitely without an indictment, because it's not our policy, which is the weakest argument in the world. I don't care if it's your policy. We're in a court of law. Is it the law? Say that I don't have to as a matter of law. I respect it. Say it's not your policy. I don't care. I don't care. This reminds me of the CPS people in front of, who was it? In front of that judge in Texas. Like our policy, I don't care what your policy is. We're in a court of law.
We have I show a suspended sentence on the criminal trespass. I was trying to match up what's on the calendar with what's in the jail screen.
So on the old bond order on 8/11.
All right, I just apologize to you. I'm cranky from this deposition. I just am. That's all there is to it.
6 and 7 were listed on there as previously dismissed. They were not. So she wants to reduce the bonds that don't count and have a bond, established for the criminal trespass.
Okay. Administrative error that these were never. Well, they're misdemeanors. $1,000 bond is certainly reasonable on each of the criminal trespasses. The bond, as set, is much, much more than reasonable, especially given the underlying facts of this case. And anytime that Ms. Hanson, Mr. Cho want to put in applications at the district attorney's office, if they're unhappy with the way the office is being run, I'm sure their applications will be entertained by Madam District Attorney.
That doesn't mean I want to work there. That means I want to crush you for being incompetent. Sorry.
Any of the personnel people in the DA's office.
I am confident I will not be doing that.
Decline as well.
All right. So
I'm better now.
We're going to leave ag assault at 2. Let's see. Disorderly, 500. Cruelty, 500. Obstruction, 500. And 250 on each criminal trespass, Ms. Tracy. Got it? Got it. All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 5555 Roswell Road and 5675 Roswell Road.
Yeah,
no drugs, no alcohol, no weapons. Gonna have an ankle well, he's been there. I mean, the alleged victim's in jail. Mr. White, what's your position on the ankle monitors?
I don't think other than the fact that we need to keep track of this defendant because he is very likely to disappear when and if he ever makes bond. I'd request an ankle monitor for that purpose, but as far as no contact with the victim, I'm not sure that's a reason for an ankle monitor here.
All right, no contact with RO's, maybe Rico, but ROCIO Nava, Omar Hernandez, and S as in Sam, N as in Nancy, that's a minor. Ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, medical, employment, just a job, where he's working, location, and things of that nature. And since that hold that pretrial shows on there, he'll have
I might be angry.
48 hours after he gets released from that hold from Sandy Springs to have that ankle monitor placed on. You got that, Ms. Aaron? Got it. Thank you, Ms. Aaron. Thank you, sir. You can leave the booth. Thank you, Ms. Hanson. I think that's your only case.
It is. Thank you, Your Honor.
All right. Thank you. All right, Miss
More to the point, it's where one of my favorite bands of all time, Granddaddy, comes from.
Sampson, I got position 14, right?
Yes, ma'am. Your Honor, we've handled my business, if I may be excused.
Absolutely.
And I believe Mr. Gunby has also left his booth.
Yeah, thanks. I think so. Thank you. So we're just waiting on, we're waiting on Cobb to bring in Mr. Foster.
I like how Manning saw all that. Judge Manning, the the Honorable Judge Manning, saw everything that was going on, but she's like, look at my call. I don't care. I'm sidestepping this. I'm not listening to all your whining. Just make your argument. I'll make a ruling. Let's move.
I believe I saw him in the booth already.
I think he swapped them out. Somebody swapped them out.
Oh.
They swapped them out to get Mr. Hernandez. So I don't know why they swapped them out, because they got the other booths in there.
Right.
Don't worry. Well, I'll talk with you to preserve it all.
Are you Mr. Foster?
And light. Yes, day on it.
Okay. It's position 14, pretrial 14, 2 CP 210641, OSHAI, Asai, Foster, 93 days with no indictment as of July 14th. There's a $50,000 good bond on kidnapping, simple battery, criminal trespass, and battery. Free trial.
Judge, 8 prior arrests total, 1 FTA in 2020, a prior domestic violence conviction in 2020, and a 2018 assault and battery. Nothing further.
Go ahead, Ms. Sampson.
Yes, Your Honor. Mr. Foster has been in the Fulton County Jail for 93 days now on a bond that he cannot afford, $50,000 bond, as you mentioned. He is 27 years old. He's been in Georgia for the past year and a half. At this time, I'm asking for a bond, for his bond to be at least cut in half, Your Honor.
All right. What says the state?
Judge, on a kidnapping, the bond is certainly more than reasonable. The state would object to any reduction in the bond in this case.
Have you folks had any contact with the alleged victim?
Looking now, Judge.
Mallory Patillo. Let's see.
And unfortunately, my internet from my home is not what I'm used to, so I'm a little bit behind.
Deputy White, I actually had prepared this position.
Oh,
you to take
okay. Thank you, Deputy Roth. I'll
Judge, regarding your question for victim contact, we did have victim contact today. And the victim in this case, Ms. Simpson, is opposed to bond. She feels she would be in danger of her and her family being killed.
I'm sorry, you said Miss Simpson?
Well, there's a witness and there's a victim. There's two. Patillo and Simpson are both named in the warrants. I looked over them. I have them both.
Yes, Judge. Okay. Sorry, I should clarify. The witness, Ms. Simpson, was opposed to bond. She indicated she felt she would be in danger of her and her family being killed. The defendant, she indicated, had made threats he would get a gun and blow her and the other victim's face off. Stated she's definitely has a fear for herself. I don't know if she's on the Zoom link today. I know she was sent a link in case she wanted to make a statement to Your Honor. For Ms. Patillo, we did not have a good number for her, so there's been a locate request sent. Your Honor, regarding the history for this defendant, I'm actually showing, I know pretrial mentioned 2 previous convictions. I actually am showing 3 different convictions for misdemeanor assault and battery in the 3rd degree out of South Carolina, and then a 2020 conviction as well. This incident involved the defendant dragging the victim from the apartment. She was kicked as she was getting up.
Sit down.
They have a 9-month-old, the defendant and the victim have a 9-month-old son together. The incident started when the defendant arrived actually at the babysitter's home. When the babysitter answered the door, he threw her phone when she went to call 911, so she was unable to call until after he had gone into her home when he found out that Ms. Patillo was there. Ms. Patillo indicated that there were 10 prior incidents of violence between herself and the defendant. Additionally, Your Honor, when the defendant received his $50,000 bond on July 14th,
I'm pre-merced myself.
Part of that was that he was to have no further contact with the victim, and he has called the victim 4 times since that bond hearing. And so the state.
All right, 3 South, sit down. 3 South, sit down. Okay, so if you don't know you're in 3 South, if you are standing up, sit down. Refuse to do it.
I'll call the,
Yeah, you're standing up, sit down.
Yeah, you.
Sit down.
He's saying something, I think.
I think he's saying he's having a medical issue, Your Honor.
Does he have a medical issue? All right.
And Your Honor, it looks like he's saying it's a possibility, probability. I'm not sure if he has a colostomy bag or something, but
Okay.
he's pulling up his shirt and doing some type of indication.
Yeah. All right. All I saw was that
Yeah,
he's
yeah.
going to have to see his face to see who he is. So he's going to have to show his face if we call his name.
But
All
we
right.
saw
See,
that.
no drugs unless prescribed, no alcohol, no weapons, no further contact with Mallory, FPATTILLO. Stay away from 6005 State Bridge Road in Duluth. No further contact with KIMORA Simpson. Gonna have an ankle monitor paid for by the county with a 24-hour curfew. You can leave for court or to see your lawyer. And I think you live outside of Fulton County, right, sir?
Yes, ma'am.
All right, good. Stay out of Fulton County unless you're here for court or to see your lawyer.
Stay out of Fulton County and stay out of
Let's
Michigan.
see. 35 on count 1, 2,000 on count 2, 2,000 on count 3, and 4,500 on count 4. 35, 2,000, 2,000, and 4,500. Ankle monitors will be paid for by the county. Let's see, if you got any holds or anything like that, you have 48 hours to have that ankle monitor placed on your ankle. Best of luck to you, sir. Thank you, Cobb.
I'm sorry, what was the total, Your Honor?
I didn't do that. Let's code out the numbers. 35, 2, 2, and 4,500. 35, 2, 2, and 4,500. Sorry, I don't do math. Thank you. You can leave the booth.
84.
Thank you, Cobb. See you later, sir. You can leave the booth. I guess we can just remove him from the. Is that all you had, Ms. Simpson?
Yes, Your Honor.
All right, thank you. Have a good evening.
You too.
All right, let's see, Cobb. We got Miss Childress. Or who's up there?
Oh, this Miss, how you doing, Your Honor?
How you doing? Who is that?
Number 5, Miss Howard.
Okay, we're just going to take that since she's right there. All right, 22CP210490, pretrial number 5, Stephanie Howard. 99 days without indictment, no bond as of July the 8th on aggravated assault. Trial.
29 prior arrests, open case 21 CR 00390-9F for battery drug related objects. 2022 FTA, 1 arrest for probation violation. Arson in 2019 to PTI and arson 2017. For aggravated assault, I believe about 2018, an ag assault in 05. 3 misdemeanor convictions, nothing further.
Right. Go ahead, Ms. Pinto.
Thank you, Judge. Miss Howard's 54 years old. She's lived in Atlanta her entire life. If she's able to, but she's granted a bond and able to be released, she will be living with her son and daughter-in-law, who I've confirmed with them. They live on Martin Luther King Jr. Drive here in Atlanta. She is already set up to start doing classes with River's Edge if she can get out. She'll be doing multiple classes with them at their College Park location. She also has a job set up if she can get out at CKS Packaging. She does have 2 sons who live in the Atlanta area. She is indigent, Your Honor. She cannot pay anything in bond at this time. She has been in, as the court stated, for 99 days, and the case is yet to be indicted. We are asking the court to set a $5,000 bond for Ms. Howard so that she can utilize the services of the bail project and start the job and start the classes that I mentioned that she has lined up. Thank you, Judge.
All right. What says the state?
Given her record, she is a significant threat to the community and a very significant threat not to either to not comply with the orders of the court or to not show up. The state would ask that any bond include a strict 24-hour house arrest. I'm not sure if the classes are virtual or that she has set up, or either are virtual or if they're in person.
Miss talking.
I heard something as well. I'm not sure what. But we would ask for a 24-hour house arrest, a stay away from the victim in this case. The exception being for the classes and for the job, if she can provide a schedule for the job and a set work site. That's all.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 4205 Fulton Industrial Boulevard. No further contact with Ricky Eugene. Can have ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical, employment. But man, you have to provide the name of your employer, a schedule, and where the location you will be. You have to supply that to your lawyer who will give it to the state, but you're also going to need to supply that with the ankle monitoring company.
Judge, I have her employment information if you want it now.
Oh, yeah, no, I'm not going to. She got to talk to him, see what her schedule's going to be, where she's going to be working, and when she gets that, just supply it to the state, like I said. And then if there's the classes with Riverside, you said?
River's Edge.
River's Edge, then if that's a schedule, it's not online, let them know about that.
Riverside, River's Edge. Come on. What else?
Best of luck to you, ma'am. Who's next, South FedEx?
Position number 8 and 9, Ms. Linden.
All right. So what position 8, Ms. Linden, you heard me earlier, was indicted. And so we're just going to cover position 9. 210562, Courtney Ann Linden, possession of Schedule 2 controlled substance, possession, use of drug-related objects, obstruction of a law enforcement officer. On July the 11th, there's $4,500 good bond. You've been in 96 days without an indictment. Wow.
Yeah, she has that other open case, 22 SC 184570, aggravated cruelty to animals, no prior arrest, nothing further.
All right. Let's see. Who's handling Mr. Tessier? Are you Miss Ross? I mean, not you. Who's handling Mr. Tessier's cases? Mr. Cazzoli, Mr. Singleton, Ms. Rosenhoover, Ms. Gowdy. Mr. Singleton.
No one gave me any information about handling this case, but I can go run down to his office to see if the file is there and come back up if we could just do this one a little later.
All right, you can run down there real quick. Just step outside and we'll take Ms. Childress real quick.
I in case I forgot, I need to give a shout out to Big and 2 who sent me all this. I didn't have it.
All right, let's see. So we'll put a pin in that one. Position 23, Malaya Clarice Childress. Position 23, pretrial 22 CP 210446. 100 days, no indictment. As of July the 7th, 2022, there is a $40,000 good bond on cruelty in the first, reckless driving, giving a false name, fair-based stop sign or traffic control devices, driving with suspended license, driving, fleeing, or attempting to elude misdemeanor, wrong side of the road, and fair to yield the right-of-way. Pretrial.
13 prior arrests, FPA in 2010, probation violation, and 3 probation violation, criminal damage to property in 2011. Currently has an open case for theft by receiving stolen property, 2 counts out of Cobb from a July the 3rd arrest of this year. Prior DUI conviction in 2020. Nothing further.
All right. Go ahead, Mr. Cazzoli.
Thank you, Your Honor. Ms. Childress.
Before her attorney speaks for her, I know where the chat's at as soon as you mention animal cruelty.
I know where there's free lodging.
32 years old. She has a good address at 344 Tarragon Way, Southwest Atlanta, Georgia, 30331. Your Honor, we're asking for a significant reduction in bond here. Out of respect for the court, I don't want to dive too deep into the details here, Your Honor, but this is I have strong objections to the charge being levied as it is. This first degree cruelty to children charge, Your Honor, is based on the fact that the child was crying in the back of the car during a reckless driving infraction, Your Honor. And I certainly plan to argue that strongly in a preliminary hearing. But as for now, Your Honor, we ask that the court reduce this bond at the very least in half to $20,000. She's been in jail for over 90 days.
All right. What's the state? Oh, Mr. Cazzoli, where is the minor child? with,
Okay, so Biggin apparently is recording this with his phone. I'm figuring out because this video is sent to me by him. God bless him for it. Yeah, it's amazing how he keeps his channel going and sends me stuff and everything else.
Your Honor, I actually don't know where she is currently.
She's with my mom, her grandparents.
okay. Do you know if there's a, all right, I got you, Miss Francis. Is there a defects case open or?
No, ma'am.
Not
Okay,
to my knowledge, Your Honor.
All right, she's just with your mom. Okay, thank you. All right, what says the state?
Hang on, Judge.
I love it. That might be a t-shirt right there.
Judge, this is a cruelty to children. I think it's much different than it was characterized by my learned colleague. The state would request that any bond set by the court include a strict no contact with the child. I understand the child is hers, and that the child is with her, with the defendant's family. The state would request that there be absolutely no contact directly with the child. Also, a strict no driving at all. As a condition, would ask that there be a 24-hour house arrest enforced by an ankle monitor expense, and such monetary bond as the court deems appropriate in this case.
How old's this child?
She's 5.
Okay, so this kid's 5. Are you 5 with her? Are you going to be living with your mom?
No, ma'am. No, ma'am.
So, Mr. White, why can't she stay with her mom and her just have like supervised time? She can go over there and see her. You can't take her. I mean, this kid's 5. I mean, and then, once it gets into a prelim, because you haven't had one, right, Mr. Cazzoli?
Correct, Your Honor. We do have one scheduled soon. I would also point out, Your Honor, that at first appearance, when we actually were able to hear the facts of the case, the judge said a no violent contact order, and we would ask that be maintained. There's no reason to increase or decrease, rather, the amount of contact she should have based on a bond hearing.
All right, tell you what. So obviously, yeah, okay, all right. No drugs unless prescribed, no alcohol, no weapons, no driving through the pendency of this case unless they modify it, okay? So if you've got
And thank you, Peter Wine.
to take, if your daughter has to go somewhere, your mom, you can go with your mom to take her, all right? Your mom can drive her in the car, not you. How about that? All right? No further violent contact. Then this, it's N. Garcia, N as in Nancy, all right? And then put in there that if the child needs to go anywhere, she can drive. You can have an ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, medical. Obviously, if it's medical concerning your child, something like that. All right. And employment, but you have to give the name of your employer, where you'll be working, and the schedule to the state, and then also to the ankle monitoring company. Okay. So let's see. Count 1, 3, count 2, 3, count 3. 1,000, count
That
4.
much might be coming.
1,000, count 5. 2,000, count 6. 2,000, count 7. 1,000 and count 8. 1,000. Got that, Mr. Tracy?
Thanks,
3, 3, 1, 1, 2, 2, 1, 1. Okay. All right. Well, those are the conditions. Okay, ma'am? Got it?
Yes.
All right. Best of luck to you, ma'am. Thank you. I guess Mr. Singleton hadn't got back yet. So we got Miss Geraldine Mason. Till Mr. Singleton gets back.
And that concludes my business, Your Honor. May I be excused?
Yes, sir. Good to see you, Mr. Gazzoli. See you next week. So, this has
Yes, thank you. And by the way, I've spoken to Lily privately, like before the and all that stuff. She's just cool. That's her. That's her. It's not fake. She's just cool.
2 cases. It's position 18 and position 19. State of Georgia versus Geraldine Ann Mason, 22 CP 210690. 91 days out of indictment. 1, 2, 3 counts of aggravated assault with a deadly weapon, possession of a firearm or knife during the commission of certain felonies, possession of a firearm by a convicted felon, and 2 counts of cruelty in the third. And there's a $75,000 bond as of July the 15th. The other case, position 19, is 22 CP 211591, Geraldine Mason. 91 days of indictment, identity theft or fraud when using or possessing identifying info concerning a person. There is a $5,000 bond on there as of 8/19/2022. Wow.
Judge O, unindicted, 13 CP 134326, aggravated battery, aggravated assault, 2 counts. Afraid, 2 counts. 12 prior arrests total, 2 misdemeanor convictions, 2 FTAs in 2014 and 15. Currently on probation for possession of cocaine, sentence in 2021 for 3 years. Nothing further.
Go ahead, Ms. Pinto.
Thank you, Judge. Ms. Mason has been incarcerated for 91 days. She does have a bond. It's a total of $80,000, which is far more than she can afford. We are asking the court to reduce her bond significantly today. If released, she will live at White Oak Drive. That's her home where she lives with her children.
Linda, you can handle it, but I don't know. I don't know about the rest of my chat. I mean, that's why I love them, but they're not to be trusted.
She has 6 children, and she also has 3 jobs lined up. One is her own business. It's an event planning business. One is at AC Construction Company. And then one is working at her friend's daycare as well. She's lived in Georgia her entire life. Her entire family lives here. She has strong ties to this community.
I think that sums it up. Yeah.
I understand that she does have some FTAs, but those were during COVID. And she explained to me that she tested positive and had informed the clerk of that court, but for whatever reason, that message didn't make it. And she did end up with those FTAs on her record. As I said, we are asking the court to reduce the bond. She would be, happy to comply with any conditions that the court sets, such as an ankle monitor. She can stay away from the alleged victim or the incident location. I understand these charges look bad, Your Honor, but we do strongly contest these allegations. And so we are asking the court to reduce her bond by half, Your Honor.
All right, what says the state?
Your Honor, the defense counsel has shown no change in circumstances that would justify the reduction of the bond. Certainly, given the fact that this is 3 counts of aggravated assault, as well as a separate case for identity fraud.
You're violator number 1.
A total bond of $80,000 is not unreasonable. The state sees no reason to disturb the bond as set.
All right.
Your Honor, I have a statement from the victim. I don't know if you would like me to read it, but the victim did send a statement that they wanted me to read.
Okay, go ahead.
Okay, the statement reads, Your Honor, I am sure our son did all he could do to please the ones who robbed him for what they wanted from him, but it wasn't enough. His life was taken as well. My son was a good man, respectful, independent man. He had a good job and good dreams like the American dream in the U.S. He would tell his parents he loved them, and the family and friends were proud of him. He loved us and we loved him. He was a fine young man. We always will remember him, and he will be missed. If bond
Judge, I'm not sure this is the correct statement. I'm very sorry to interrupt, but
no, this was sent to me from a victim's advocate on another case that he's involved in, and apparently he forged when it came to this.
Well, this is Geraldine Mason. It's a female.
The identity theft fraud, that part of it, what I was told by victim's advocate from the murder unit is that the person then sold the car of the deceased. That's what that's where the identity fraud comes in. So this is coming from that.
I think this isn't the ag assault. Somebody didn't die.
That's you, JoJo.
From the ag assault.
Right. So this is this case. This
you're not the
This is about stealing a deceased person's identity. I got you. Go ahead.
If bond is given, the suspect might leave town. Then we might never get answers. We'd like to know why steal his wallet, his cars, sold the car before we even knew he had passed. My dead son's car was sold
It really is.
to the salvage location by the suspect, who has been found as the person that forged his father's name on the title. The charge is way more serious than how it sounds. The property in question was a car that would be considered evidence for a homicide. The suspect is a co-defendant for 2 gang members who are being charged with murder. We strongly request bond not be granted due to the danger she is to the community by having close ties with gang members and aiding them with crimes. With her other charges, she has also shown that she is a violent person as well. So please, Your Honor, deny bond for the suspect to protect our community. Yours truly, Mary Stewart and Seaborn Kelly Sr., who is mother and father of Seaborn Kelly Jr.
But not the ag assault victims. What says the state?
Judge, as you said, there's no change in circumstances.
Any talk with the ag assault victims, I guess. That's kind of what I'm...
Oh, okay. Hang on, Judge.
That would be Todd and Shorter.
Judge, I'm not able to access or the internal documents with the district attorney's office, so I cannot answer the court's inquiry on that. I apologize to Your Honor.
No, all right. So I'll go with position 19 while she's looking that up. On the identity fraud, I'm going to leave it at 5,000. No drugs unless prescribed, no alcohol, no weapons, and no further contact with the family or the estate of Seaborn Kelly Sr. Stay away from $898. I'll leave that at the $5,000. All right. Do you see anything, Ms. Roth, on victim contact or no?
On the aggravated assault case for Geraldine Mason?
Right.
No, Your Honor. The last contact that
I hate how you all see through me.
seeing was when they were contacted to be informed of first appearance.
Okay. All right. Right, no drugs unless prescribed, no alcohol, no weapons. This is for position 18. Stay away from 1221 Epworth, EPWRTH Street, Southwest in Atlanta. No further contact with ZIYA, last name Todd, TODD, Denardo, DERNARDO Shorter, and Shmarion, SHUMARION, Todd.
Shmarion.
No drugs unless prescribed, no alcohol, no weapons. You're going to have an ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer. Her children are smaller. Or are they adults, Ms. Pinto?
Message me.
Sorry, Judge. They're pretty small. The oldest is 14.
Okay. Since you have your children, you can leave if your children need medical attention. Not going to keep you from leaving if you have to take your children for medical attention. All right? So, let's see. This bond was set in July, so we got 10 on count 1, 10 on count 2, 10 on count 3. I'll leave count 4 at 10, 10 on count 5, 2,000 on count 6, 2,000 on count 7. I don't think there's any holds, but if there are, then you'd have 48 hours to have that ankle monitor placed back on you. We got all that, Ms. Aaron? 10, 10, 10, 10, 10, 2, and 2?
I got it.
All right. Thank you, ma'am. You can make a move.
I'm in. Let's do that. Let's have a lot of talk with Mike. Field trip to Fulton County. We'll see Judge McBurney. We can see Judge Manning. We can go over to DeKalb and see Judge Lau. And who else do we have? Who else do we have in there in Georgia? Judge Knights he's in Clayton. These are all surrounding counties. I don't know Georgia. The only time I think I've ever, the only time I've really spent in Georgia was last weekend in Savannah, and I got to tell you, it was pretty damn good. I'm not going to lie to you. I was charmed. It's good stuff. All right, you guys got me with so many today. I will have you know. Wait. Who's this guy? Who's this guy showing up? Look at that. Have him on the channel a couple days ago. Now he thinks he just owns the place. That's what's going on. Thank you, Biggin. Seriously, that was video sent from him because I was busy and I wasn't recording that, so that's why I have it. I admit I did ignore like the last two hearings because you guys are making me laugh. You're making me laugh. It's the chat's fault. I like this. I've got a new angle. I just blame the chat for. I blame the chat for making all the bad jokes that I want to make but can't. And then I can feign disgust with it. It's beautiful. All right. Thank you all for coming out. That's the best I could put together on short notice. What do we have? We had Stanislaus County where a defendant actually came to his senses and said, you know what? I actually don't want to represent myself. And it worked out well for him. It did. Oh, thank you, Jude. And then, of course, that's the ultimate compliment to Judge Manning. I got to see about 20% of that at best. And I'm just confident enough that she's cool and her call is crazy enough that it just doesn't matter. I can just go in blind and run that. I can just do a stream. And it didn't disappoint. Maybe I should have the prosecutor on. I gave him a hard time. Maybe I should let him on to defend himself. What's the guy's name? Knight? I don't know. I got to be in court yesterday to tell on 5 days free accommodations at the Gray Bar Hotel. I even got to see him at the bus stop a few days earlier. Ooh. I haven't checked up on Glenn Serio in a while. There's been so much crazy. So much crazy. The Glenn Serio has just kind of faded away. But that was fun while it went on. I'm sure it'll blow up again. And I'm sure that Chili will end up in torture cuffs soon enough. And, some of our favorites. A lot of our real favorites, like Jeremy DeWitt. I mean, he was in jail, and then he got out, but then he went right back to jail. So, I don't know if he's going to do anything. We've got so many. Looks like my man, and he's been on, and I'm actually kind of fond of him in a way, even though he's insufferable in court. But Blandino, it doesn't look like he's going to get out for a while. Gainesville, Gainesville, Florida. That's all good. That's all good down there. I love Florida. All right. I'm gonna not babble. Thank you all. I needed the therapy. Honestly, I was so cranky coming out, and I just had to throw it together. And I was cranky as could be, but you guys pulled me out of it. What's this business? Oh, good Lord. What is going on over at Lawn Lumber? I showed up. I will give myself credit. I showed up from Savannah to Lawn Lumber. And I mean, I didn't put in a good performance. But I attended last week. And the lovely and gracious Miss Deborah Davis was there, which is always good. Look at that. Rob. All right. Maybe I'll stop in over there. I don't know. Maybe I'll stop in over there. Or maybe I have another deposition scheduled. I'm not sure yet. Thank you all for coming out. Seriously, y'all cheered me up. I don't know if that's the point, but that's what happened. Thank you all. I will see you soon.